Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law. We bring you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. Starting with an update on the bike taxi operations of Rapido. As you know, in February, the Delhi Transport Department had issued a public notice to stop plying bike taxi services. But in May, the Delhi High Court, while issuing notice to the Delhi government on Rapido's plea, had directed that no coercive action be taken against the bike taxi aggregator till a final policy was notified. A special leave petition was then filed by the Delhi government challenging the High Court's order, which stayed the notices issued against Rapido and Uber. Last week, the Supreme Court had sought the centre's response on the plea. Today, the Supreme Court has stayed the order of the Delhi High Court. The Supreme Court vacation bench, comprising Justices Aniruddha Bose and Rajesh Bindal, also recorded the statement of senior advocate Manish Vashisht on behalf of the Delhi government that the concerned policy would be in place and the licensing regime would be operational by 31st July this year. The Bombay High Court today issued notice to the NIA on a fresh bail application filed by senior journalist Gautam Navlakha, who has been arrested in the Bhima Koregaon Elgar Parishad case and is accused of having CPI Maoist links. Observing that the trial court gave cryptic reasoning while refusing Navlakha's bail plea, the Bombay High Court on March 2nd this year had directed the special NIA court to hear and decide the case afresh. Navlakha has approached the High Court after his bail plea was re-adjudicated and he was denied the bail. Navlakha is currently under house arrest after Supreme Court allowed his transfer from jail to house arrest on account of his medical condition in November 2022, subject to various conditions. The 73-year-old human rights activist had been in custody since August 2018. The division bench headed by Justice A.S. Gadkari will now hear the matter on June 28th. Stay tuned with us. The Delhi High Court today permitted a 13-year-old minor rape victim to undergo medical termination of pregnancy with 24 to 26 weeks old fetus. A vacation bench of Justice Jasmeet Singh also directed the Delhi State Legal Services Authority to look into the compensation to be paid to the minor. On the direction of the court, a medical board had reviewed the minor's case for medical termination of her pregnancy and concluded that continuation of pregnancy in this case carried higher risk to both the mother and the fetus. As per the status report filed by the Delhi police, the 13-year-old had gone to her grandmother's house where she was raped by a person who was a tenant in the same locality. The minor then went to her native place in Bhopal, where she fell unwell, and her parents took her to the hospital, where it was found that she was pregnant. The Delhi High Court has ruled that it is the discretion of the applicant to choose either High Court or trial court for moving an anticipatory bail plea, and his discretion cannot be restricted by interpreting Section 438 of CRPC in a narrow manner. Analyzing the provision, the vacation bench of Justice Chandradhari Singh said that there is no bar on approaching the High Court directly for seeking anticipatory bail, and that both the courts have concurrent jurisdiction to deal with such cases. Justice Singh made the observations while granting interim protection to Pankaj Bansal and Basant Bansal in a money laundering case registered by the Enforcement Directorate in 2021. Coming to an update from the Punjab and Haryana High Court, observing that a DNA test cannot be ordered in a manner that leads to a roving inquiry, the Punjab and Haryana High Court has set aside the order of a family court which had allowed a 26-year-old woman's application for DNA test to prove that her mother's former live-in partner was her actual father. The court was hearing the revision petition filed by the alleged father against the order of the family court. Justice Alka Sareen said that the courts in India could not order blood test as a matter of course. In the present case, the parties had already led their evidence in support of their respective stands, and the alleged father could not be compelled to adduce evidence in support of the case set up by the daughter. The Karnataka High Court has refused bail to an accused charged in the 2020 Bengaluru riots, citing primacy of public safety and collective interest of the society over individual liberty as guaranteed under the Constitution. A division bench of Justice Krishna S. Dikshit and Justice Pradeep Singh Yerwar also refused to apply the concept of bail is the rule and jail is an exception. Turning down the other contention that there is presumption of innocence of the accused till the guilt is proved, the bench noted that even this norm was subject to exceptions. An anticipatory bail plea has been moved in the Kerala High Court by Vidya K, who has been accused of having submitted a forged experience certificate in the interview held to the post of guest lecturer at the Attapadi Rajiv Gandhi Memorial Arts College, Palakkad. She is alleged to have produced forged experience certificate in the name of Maharaja's College Ernakulam and as per media reports is currently in hiding. The bail plea avers that both the offences under which she has been charged for forgery, that is section 465 and 471 of IPC, are bailable and that the present case has been initiated for political reasons. The Karnataka High Court has confirmed the death sentence handed down to an accused by the trial court for murdering his wife, sister-in-law and 3 children below the age of 10 years, suspecting the faithfulness of his wife. A division bench of Justice Suraj Govindaraj and Justice G. Basava Raja said the case qualified the test of rarest of rare cases requiring the award of the death penalty. As per the FIR, the accused in February 2017 assaulted the deceased with a chopper and then came out of the house shouting with happiness. The prosecution had examined 36 witnesses, based on which the trial court convicted the accused and sentenced him to death penalty. The accused challenged the order of conviction and the state government appealed for confirming the death sentence. Observing that right to identity is an intrinsic part of Article 21, the Delhi High Court has said that it is permissible for an individual to change his or her surname so he may not be identified with any particular caste that may be a cause of prejudice to such person. The court was hearing a plea moved by 2 brothers challenging the letter issued by CBSE in June 2017, refusing to change their father's surname in the 10th and 12th board certificates. The father had already carried out the change in his surname by way of publication in Gazette notification, and that the new surname was duly reflected in various public documents issued by government agencies. Therefore, the court directed CBSE to carry out the requisite changes to reflect the changed surname of the father. However, it clarified that the change in surname in the CBSE certificates would include only the change in their father's name and not the change of their caste, for them to take any advantage of any reservation or other benefit available to the changed caste or surname. The Kerala High Court has directed the Travancore Devaswam Board to take immediate measures to improve the health conditions of the cows and bulls at the Gaushala of Vaikom Sri Mahadeva Temple. The division bench comprising Justice Anil K. Narendran and Justice P.G. Ajit Kumar issued the directive while considering the suo motu proceedings initiated on the basis of a news report highlighting the lack of proper care for cows in the Gaushala of the temple. The matter has been posted for further consideration on 14th June. Stay tuned. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.